Today we're going to continue with excuse doctrines, or at least with doctrines that parties are going to use to try to get out of their obligations under a sales contract. So last class we were focusing on mostly seller doctrines of commercial impracticability. Today we're going to focus on a doctrine that's largely used by purchasers, although I suppose theoretically could be used by sellers, but mostly is used by purchasers to argue that the terms of their contract should no longer apply to them in some respect. Your book mentions Professor Leff's analysis of unconscionability doctrine and the division of it into two prongs, a procedural prong that focuses on unfair bargaining and a substantive prong that focuses on unfair terms. What your book leaves out is really my favorite characterization of Professor Leff's, which is that unconscionability is really about what he calls bargaining naughtiness. And I just think that's sort of a fun, lighthearted, but also pretty good reflection of the really highly subjective nature of what makes something unconscionable. One person's naughtiness may be another person's, oh well, kids will be kids. I say this as someone who's been spending a lot of time looking after two toddlers the last few days as we hunker down for COVID-19 2020. And so there is a certain amount of subjectivity to this doctrine, particularly in the context of UCC 2302, which talks about unconscionability, says that contracts for sales can be unconscionable, does talk about what sorts of things a court can do with an unconscionable term and how the court ought to consider evidence, but doesn't really say much about actual elements of unconscionability. As your book points out, it really is a little bit circular, tautological. Something is unconscionable if it is unconscionable. So, first of all, I want us to focus on who makes the decision as to whether or not something is unconscionable. And that is a question for the court, as comment 3 to UCC 2302 makes clear. The present section is addressed to the court and the decision is to be made by it. And in part, I think that the adopters put this in the comments because the doctrine is traditionally an equitable remedy. So a court sitting in equity would have heard it, but also because juries tend to be swayed by sympathetic plaintiffs. And so it's thought that a judge is going to be the most appropriate person to hear parties' claims as to unconscionability. The comments also in comment 1 suggest a test, even though the language of 2302 does not. And what it seems to say here is that in light of the commercial background and the commercial needs of the particular trade or case, the clauses involved need to be so one-sided as to be unconscionable under the circumstances existing at the time of making of the contract. And they say the principle is one of prevention of oppression and unfair surprise, and not disturbance of allocation of the risks because of superior bargaining power. And I think that those two elements don't track 100% onto these procedural and substantive prongs that Professor Leff suggests and which have been widely adopted by courts, but they do suggest that oppression is often viewed in terms of pressuring somebody into making an agreement, and unfair surprise can focus on how easily understood were the terms of the agreement. Some courts, taking a little bit further, will look at, did the parties really understand the consequences of the terms? And this notion of one-sidedness really comes into play in courts looking at the substantive elements of the transaction. So is it designed in a way that really seems to disproportionately burden or hurt one side to the transaction? What 2302 does include is the actual remedies that a court can award if there has been an unconscionable term. And it makes clear that courts can do a few different things. Right? They can refuse to enforce the contract, enforce the remainder of the contract without the unconscionable clause, or limit the application of any unconscionable clause as to avoid any unconscionable result. And this is very much in line with what our common law doctrine that you might have learned in your contracts class allows. So once again, courts can refuse to enforce the entire contract. So they can declare the entire contract unconscionable, thus allowing the party claiming unconscionability to avoid the contract entirely. Now keep in mind that when we're talking about avoidance and you rescind a contract, if a party has received benefits under that contract, then typically there has to be some sort of restitution by the party who received the benefit along with the rescission of the contract. So it's quite likely that many parties won't want to rescind the entire contract, but will instead want the particular provision that they believe to be unconscionable to be limited or to be revised in some way. And that act of the court going in and revising a contract, perhaps by just excising the bits that the party seeking an unconscionability claim doesn't like, that act is sometimes called blue penciling. So if you hear people talk about blue penciling, that's what they mean, where a court might say, well, this is unconscionable, I'm going to sever this clause. I know that a lot of contracts courses cover this case, Williams v. Walker Thomas Furniture, so I don't want to belabor the point too much. As your book points out, this case is commonly cited as a standard for unconscionability. So this idea of an absence of meaningful choice on the part of one of the parties, together with contract terms which are unreasonably favorable to the other party. And this case essentially involved a rent-to-own furniture and home goods outfit that had engaged in a series of transactions with a plaintiff who really did not have the means to purchase at their face value a lot of furniture items. And with each contract that she entered into with this company, the payments were allocated pro rata for each item that she had already purchased through the company. And so while she thought that she was paying off each item as she got it, it turns out that her payments were being diluted, and when she missed a payment, they repossessed all of her goods. And so the question was this appropriate? And the DC Circuit Court articulated in their opinion this legal theory of unconscionability. This idea that there needs to be the absence of meaningful choice and terms which are unreasonably favorable to the other party. Now, interestingly, in this particular case, they didn't necessarily decide for the plaintiff. Instead, the case was remanded down to the trial court. But I think parallels can be drawn between this case and the case that is in your textbook, Maxwell v. Fidelity Financial Services. So in that case, we have our, as the court presents it, very working class homeowners, Elizabeth and Charles Maxwell, versus Fidelity Financial, who was the financier of this, frankly, boondoggle solar heater that they ended up purchasing. So they bought this solar heater on an installment plan, and it ends up being secured. The loan for the solar heater was secured by a lien against their property, their home, and the heater never worked. Later, the Maxwells went to Fidelity for another loan of $800 at a 19.5% interest rate, which is an astonishingly high interest rate. The water heater came to $14,860 in total payments for what was supposed to be a $6,500 item. The trial court, hearing all this, grants summary judgment for Fidelity. Right? The appeals court looks at the case and tries to decide, was the ultimate loan unconscionable? And the appeals court looks at this and says, we can decide this not on the procedural prong, because it seems as though the Maxwells entered into this contract knowingly and voluntarily. But this is on page 285 of your text. A claim of unconscionability can be established with the showing of substantive unconscionability alone, especially in cases involving either price-cost disparity or limitation of remedies. And in this case, it was very much that price-cost disparity that seemed to be concerning the court. The price struck them as grossly excessive. And so ultimately what the court decided was to vacate and remand to the trial court with a concurrence saying that the court should just find this is unconscionable on the facts. And so how do we contrast these cases that seem to suggest that there are parties out there who might be taking advantage of people who do not have other options, with the notion that when you have a body of, we'll say, consumers or potential contracting parties that present a credit risk, who do not have the means to access the markets that you might typically think, like, why don't they have a credit card? Why don't they have a bank? How do we balance these, frankly, almost usurious, illegally high interest rates that these companies are charging, which, just to review, in a case like Maxwell v. Fidelity Financial, the court seems to say are substantively unconscionable, with the procedural element, which is these parties knowingly entered into these contracts. There's no allegation that any of the terms were hidden from these parties or that they were forced to enter into these agreements. And so the debate that we see playing out in the text is between courts that would say the terms themselves are substantively unconscionable, and the courts that say, but procedurally, these seem to be fair agreements. And the fact that the terms are not good is a reflection of the credit risk and bargaining power of the parties. As Posner puts it, since the law of contracts cannot compel the making of contracts on terms favorable to one party, but can only refuse to enforce contracts with unfavorable terms, it's not an institution well designed to rectify inequalities in wealth. And so how do we balance these elements? And going back to our friend Professor Neff, he doesn't say in his article, and courts are frankly very much divided on whether you need to show both procedural and substantive unconscionability, or whether one of those is enough to show that a contract is unconscionable. In the Maxwell v. Fidelity financial case, the court seems to rule solely on the substantive terms, the financial terms of the agreement, and not on the procedure. So let's finish with a couple of cases looking at leasing agreements. And the actual language of Article 2A looks very similar to Article 2, except that it seems to say more about the actual procedural element of how collections occur when a party has failed under a lease. And to be more specific, when we're talking about collections, we're talking about the lessor's right to repossess the goods. So UCC 2A108 has a couple of additional areas for relief. First of all, unconscionable conduct, and second of all, unconscionable collection procedures. It also has a fee shifting provision. So before we talk about these cases, let's do a quick hypothetical. You're looking to lease a used car, but it needs to have good gas mileage. You ask the dealer if the car you're looking at, let's say it's a BMW 7 Series, has good gas mileage. And the dealer speaks at great length about how great the gas mileage is. Okay, you say, because I'm not going to lease this car unless it gets at least 30 miles a gallon. I promise you that this car gets at least 30 miles a gallon, says the dealer, knowing that while a BMW 3 Series generally gets good gas mileage in the 30 plus miles per gallon range, a 7 Series often does not. However, he's thinking about the fact that his contract has a merger and integration clause, and he thinks that that could help block any parole evidence. So how might 2A108 help? And one thing that we want to think about broadly in unconscionability is that a claim of unconscionability bringing in outside evidence might help get around the barrier that the parole evidence provisions seem to present for extrinsic evidence. So let's talk a little bit about Pantoja Chue versus Ford Motor Credit Company. This is one that I think is really helpful to visualize here. We have a case where the plaintiff is alleging he signed an agreement believing it was a purchase agreement based on the representations of a Spanish-speaking salesperson. Only later did the plaintiff discover that what he had signed was a lease agreement, not a purchase agreement. He had already sued, but in the course of this lawsuit, it seems, I'm reading somewhat between the lines, that he stopped making his payments, at which point Ford hired somebody to go in and repossess his car, the plaintiff's car. And it seems that they accomplished that by breaking into his garage and taking the car. Eventually, the parties settle their lawsuit, but the plaintiff comes back and sues again because he wants to go after the finance company for their repossessing of his car. The court looks here at a couple of key issues. First of all, they say the plaintiff cannot claim an unconscionable contract against Ford Motor Company when it was not, or Ford Motor Credit Company, I should say, the financier, when it was the salesperson Webb who allegedly tricked the plaintiff into signing the lease rather than the purchase agreement. And the court also points out that repossessing a car is not unconscionable because it was allowed by law under the terms of the agreement the plaintiff had signed. So I think this case is a nice cautionary tale, lest the first case make you think that courts are inclined towards findings of unconscionability, because indeed courts are very cautious about finding unconscionability. Similarly, we see this leasing case of BMW Financial versus Smoke Rise Corporation. So in this case, Smoke Rise had an option to purchase a rental vehicle at the end of the lease, but decided to turn the car back in, subject to a provision in the contract that called for a 15-cent per mile fee over 85,000 miles. And Smoke Rise refused to pay that additional fee. It turns out that they also had a buyout provision where the defendants could purchase the vehicle for about $17,000, which ended up being pretty close to the $14,000 that they were going to owe for the over mileage fee they were going to pay. The trial court denied a motion for summary judgment. The claim that Smoke Rise is trying to make is that this excessive mileage fee is unconscionable. The court looks at the term itself around excessive mileage and says, we need to evaluate unconscionability as of the circumstances of the time of the contract, when it was originally made, and determine whether, in light of the commercial needs of the parties involved, the agreement is one in which, and here they articulate what I would say is a fairly tough standard, right? So, looking at the circumstances at the time the contract was originally made, was it an agreement in which, quote, no sane man not operating under a delusion would make and no honest man would take advantage of? In other words, hearkening back to your days in contract, is this a provision that shocks the conscience of the court? And here the court says, no, this doesn't shock our conscience. For a 15-cent per mile fee is not unreasonable. It doesn't shock the conscience of the court. The judgment of the trial court was reversed. And I have to imagine the court here, whether they state it or not, is looking at the price differential and saying, you could have just paid $14,000 to keep the car versus paying almost $17,000 in fees. Why are you bringing a lawsuit in front of the court? So what I think it's important to think about as we are going into our questions for our class discussion on Thursday is, how does the equitable balancing work in these situations? Looking at both this idea of procedural oppression, was there something about the conduct of entering into the contract that seemed oppressive or amiss, along with the substantive prong of the terms themselves? Do they seem overly one-sided? Looking at those two together, what seems reasonable in the eyes of the court? So think about both these procedural and substantive prongs, realizing that some courts require both, and some courts do a balancing act and say, if we find a lot of procedural or a lot of substantive, going back to Professor Neff's immortal words, bargaining naughtiness, is that enough for a court to either say, we are going to limit the term, we are going to sever the term, or we are going to allow a party to avoid the entire contract, all of which are remedies that are available under UCC 2302. So we'll talk more tomorrow.